Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about rap music. Cases that should have gone to the Supreme Court of Canada, but didn't. Lamar Skeet was on trial for a murder. The Crown's theory of the case was that he had killed a person in retaliation for fingering him in another crime. During the course of the trial, the prosecutors discovered that Mr. Skeet had posted rap lyrics online confessing to the murder in the course of his lyrics. They applied to have those lyrics introduced as evidence at trial and admissible for the truth of their contents. They were successful in their application, and although the Court of Appeal disagreed with the manner in which the judge did the assessment, they ultimately found that the lyrics would have been admissible anyway, and Mr. Skeet was convicted. This case raises very important issues about whether or not creative expression and your creative expression in your musical lyrics should be admissible evidence in a criminal trial. The Supreme Court of Canada could have taken this opportunity to hear this case and to determine the limits of the application of the hearsay rule to the freedom of expression and the creative expression of individuals in their rap cases.
Hello.
Oh, hi. It's Chief Justice Beverley McLachlin.
Well, I'm so happy to be here. This is such an interesting case. The question, of course, is whether the Supreme Court of Canada should have granted leave. Now, I would not be one to ever disagree with the decision of the Supreme Court of Canada. And in this case, I think they were probably right, because the test for granting leave to the Supreme Court of Canada is an issue of public importance. Now, you can say that it is an issue of public importance to determine whether artistic, creative expression is capable of proving guilt. But on the other hand, it's just another way of expressing yourself. And the law has never, to my knowledge, said that there's a privilege for expression just because it has artistic content. I think where this case really had to be decided was on the trial judge's determination of whether the prejudicial value outweighed the probative value. And the issue really would have been whether an artistic, lyric, poem, whatever, has any probative value. Does it really mean that this fellow was confessing, or was he just using his imagination to create something? And often artists create fiction. So had I been arguing this, I would have said, look, this is just a fictional matter. It has no probative value. And that, of course, would have been something his counsel would have had to argue. I don't know whether that was argued or not, or whether it could have been argued. So in the result, we have a situation where the trial judge apparently thought it did have probative value. Probative value sufficient to outweigh any prejudice and let it in. So that is a proper principle. The question then is whether he made a mistake in doing that. The Court of Appeal said he did, but substituted its own decision. But for me, the big question would be, does an artistic expression like this have sufficient probative value to outweigh the prejudice?
Well, there you have it. I guess this week's episode is cases that shouldn't have gone to the Supreme Court of Canada and didn't. You're watching Cases that should have gone to the Supreme Court of Canada, but didn't. Tune in next week for another exciting episode of Cases that should have gone to the Supreme Court of Canada, but didn't.